Thank you for attending this continuing legal education program presented by UNM School of Law and the Leifer Board of Justice Initiative. The Leifer Board of Justice Initiative is a project sponsored by the School of Law and the Jacqueline M. Leifer Foundation. Its mission is to address the ongoing humanitarian crisis at the border. Women, children, and families fleeing persecution are being subjected to inhumane conditions and abuse as they seek a better life. This CLE will be recorded. Please turn off your video feed if you do not wish to be seen in the recording. Please keep your microphone on mute. We will reserve the last 10 minutes of the CLE for questions. If you have any questions during the CLE, please type them into the chat and a moderator will read them at the end of the presentation. The CLE is approved for 1 New Mexico General Continuing Legal Education credit. Please certify that you attended the CLE by going to UNM's online certification page. The URL is at the bottom of the email you received this morning with the link to this Zoom presentation. It will also appear in the chat. If you need help with your CLE certificate, please email the address in the chat with the subject line CLE certificate. Today's slides will be sent to attendees after this presentation. They are not intended to be legal advice. If you are interested in getting involved, or if you have any questions about the Leifer Board of Justice Initiative, please email Christina Vasquez. Her email address will appear in the chat. The Leifer Board of Justice Initiative will host a CLE session on Friday, July 30th on representation in domestic violence, family, and gang violence matters on matter of AB3 and LEA3, and the Central American Minors Program on August 6th. Today, we would like to welcome presenters Rebecca Kitson, Jessica Miles, and me, Carol Suzuki. Becca, on to you to introduce us.
Hello, everyone. Thank you for spending your lunch hour with us. We appreciate it. For myself, I'm an alum of University of New Mexico School of Law. I have my own firm and I practice immigration law, employment, family-based, and removal defense. I've also been teaching at the law school since about 2009, and I currently serve as the chair of the Texas, New Mexico, and Oklahoma chapter of the American Immigration Lawyers Association. Jessica Miles, who is with us, is also an alum of the University of New Mexico School of Law. Since 2019, she's had her own firm where she represents immigrants at the US-Mexico border in El Paso. To that end, she's a co-founder of the Borderland Immigration Council, a binational coalition of attorneys, nonprofits, and NGOs committed to documenting human rights abuses at the border and advocating for migrants' rights at all levels of government. Professor Carol Suzuki is professor of law at UNM. She teaches in the community lawyering clinic where she supervises students on various immigration matters, family law cases, and delinquency defense. She also teaches torts and is the faculty advisor for the New Mexico Law Review. Professor Suzuki earned her JD from Columbia Law School. All right, so we have a ton to cover, so I'm going to get started right away. First of all, we are going to start with some of the changes with USCIS, with the United States Citizenship and Immigration Services. There have been a ton of changes under the new Biden administration, both at the level of USCIS, so the benefit granting agency, where we've seen a lot of policy shifts, changes in the policy manual. We've also seen major shifts with the enforcement system, with the immigration court system. Jessica is going to cover some of that. And Professor Suzuki is going to go over some of the massive changes that we've seen in case law as well. So without further ado, some of the things that we've seen with USCIS have had to do with the rescission of the Trump era policies with USCIS. And a lot of times these rescissions have resulted in restoration of prior policies that existed either prior to the Trump administration or even before. One of the major things that we saw to start off was guidelines restoring the 2013 policy about RFEs and NOIDs. So during the Trump administration, what we saw was a policy, I think it started in 2018, where they would not issue a request for additional evidence in order to complete a case, that they could just go ahead and deny the case. The agency was authorized to, instead of completing the case with a request for additional evidence or a notice of intent to deny, the officers were allowed to simply deny the case, which would then create additional burden to the government and to applicants to completely reapply for the case instead of simply responding to an RFE or a NOID. That we are now back to the 2013 policy, which includes that they can issue these requests for additional evidence where the case otherwise seems to be eligible for a benefit, but needs an additional piece of evidence or explanation in order to be able to complete the adjudication of the case. Another piece similar to that is there's been a rescission of the notice to appear policy. That was actually a rescission that took place on the very first day that President Biden took office. It restored the notice to appear policy back to 2011 guidance. Essentially, during the Trump administration and since 2018, if any application was denied, the government was directed to issue a notice to appear and therefore initiate removal proceedings against applicants. So that would be even for humanitarian relief. So those that were victims of domestic violence or sexual assault, victims of violent crime, under self-petitioners for VAWA relief, self-petitioners, victims of human trafficking, everyone who was not successful in their case would automatically be put as part of the immigration court backlog, essentially. That, of course, fed a much, much greater backlog, which I think Jessica will speak briefly about. Now, the direction is back to only issuing notices to appear when it makes sense, according to the generalized guidance regarding prosecutorial discretion. That in general, a notice to appear should not be issued unless an individual falls under a very limited short list of individuals, to include egregious public safety cases. So those would be where an individual has been arrested or convicted of certain aggravated felonies, to include human rights violators, known or suspected street gang members or Interpol hits, or those who have had felony, who were removed after a felony conviction. So it's a pretty short list of individuals. I think that for the criminal defense attorneys who are amongst us, one of the important factors here would be to highlight that if gang membership or gang involvement is something that has woven its way through these newer policies. So simply that if there's indication within the official record about that can still trigger enforcement action against an applicant. Also, the public charge rule of 2018 has been rescinded, and we've gone back to the 1999 guidance regarding public charge. Public charge still is a ground of inadmissibility in the statute. However, it was expanded, bloated during the last administration with incredible expansion that had a huge chilling effect across the board, both with the Department of Homeland Security, USCIS, as well as the Department of State. That now that it has been rescinded, the horrid form I-944, which was the public charge form that was created under the last administration, has now been revoked. So they are back to considering the general 5 factors that have been in place for over 20 years that include age, health, family status, financial status, education and skills, with a real heavy focus on the Form I-864 and the generalized sponsorship requirements, that a properly executed sponsor and an I-864 weigh heavily in the overall consideration of the totality of the circumstances and overcoming the public charge. And just a quick little bit there that there's no more requirement for those with immigrant visas to prove that they have health insurance. That was another move that was quashed. Okay, let's move on. Oh, just one other quick thing too. Public charge was also subject to a ton of litigation. The Department of Justice has now said that it will no longer defend those cases. This next couple of slides, just a couple of quick updates for survivors cases. Guidelines, there's new guidelines to minimize the backlog of U visa petitions, which is huge. This is a really big shift. Essentially, what USCIS is going to do is they're going to review the backlog of pending U visa petitions for a bona fide determination, the BFD, which I keep for some reason reading in my head as BFE, but it's actually BFD. We have yet another acronym to add to our collection of alphabet soup. The thing about U visas now is that we currently have 270,000 petitions pending with USCIS. So the backlog is immense. What they have been doing is they've been going through those cases in order to figure out if someone qualifies for deferred action status, and then they're placed on a waiting list and in the quota to receive the actual U visa status in the United States. Of course, there's only 10,000 available per year. I was joked that I went to law school because I can't add or subtract, but 10,000 visas available per year, 270,000 backlog. We're talking about an incredibly long time for someone to be receiving an actual U visa. So, we had this wait list process going on. However, given the volume of the cases, it was taking about 5 years even just to get a work permit and the deferred action status. Lots of litigation, lots of lawsuits. And this has been USCIS's response. Now we basically have a 3-tiered system with the pending U visas. So they're supposed to go through them rather quickly, determine whether or not there's a prima facie case for a U visa. And if there is, they will now issue a work permit, employment authorization document valid for 4 years and deferred action status. If for whatever reason, they defer the BFD for further adjudication, they will then drop into the wait list adjudication time to eventually be put in the quota list. So there's really 3 tiers now with the pending U visa backlog. From what I have read, there's no 765, no additional work permit application that needs to be submitted, nor should there be a charge for that. So they should be considered automatically for these. So it's a really big shift. Of course, it's not clear exactly how they're going to hurry up, given the fact that they've been so slow until now, and given the fact that there's not been a huge hiring push as far as I've known, but we will hope that they will somehow manage to get through at least part of that backlog and get people into deferred action status. Another quick update here. The U and T visa after acquired spouse cases. So given the very long pendency of U visa applications, if someone files an application and then gets married during the years and years and years that they're waiting for the final adjudication of their U visa case, it was USCIS's position prior to June of this year that after acquired spouses did not qualify because the qualifying relationship needed to exist prior to the filing, not prior to adjudication. The Ninth Circuit in the Medina Tovar case decided that interpretation was arbitrary and capricious. And so USCIS has just adopted that Ninth Circuit decision as the law of the land. So it means that if someone gets married while their U visa application is pending, that spouse would then qualify for the BFD and the consideration for deferred action, as well as work authorization, and ultimately to be included as a derivative in the final U visa determination. Okay, last bits. Haiti, back on the TPS list. There's been a bunch of developments with TPS. There's the a link here to the TPS page on USCIS. I encourage everybody to check it out and see what's happening. There's all sorts of updates about litigation and extensions and all of that. USCIS also decided that they will now issue 2-year work permits for those who have pending adjustment of status applications. It used to be 1 year and then you'd have to renew, and just given the long pendency and the backlog in general with USCIS, especially in our COVID world, they've now started issuing them for 2 years, which is welcome. They will also do so for renewals. They've decided that they're no longer going to reject forms based on blank spaces. This is for humanitarian applications. Under the last administration, it's estimated that over 60,000 applications were rejected because of a blank space. So they are now going to go back and process those. That includes freezing individuals' ages for benefits. There's some additional pieces there. So kind of correcting that error. And travel restrictions for Canada and Mexico have been extended until 8/21. So that just happened just recently. So there are still restrictions based on the ongoing pandemic. One little final bit that I just saw today, that the National Visa Center, the National Visa Center issued their updates that there are currently 532,000 immigrant visa applications that are backlogged. So for those who are consular processing and waiting for their green card cases through the consulate, it's well over 500,000. Probably most of those are with CDJ in the Ciudad Juarez, the Mexican consulate that is processing. So lots of backlogs, positive developments still. We are going to move on. I will hand it over to you, Professor Suzuki, to talk about some case law.
Thank you, Becca. I will run through a selection of some recent cases in immigration. I will not cover the new matter of AB and matter of LEA regarding domestic, family, and gang violence. This area of practice is the focus of its own CLE on July 30th. I thank the many practitioners who have analyzed these cases, plus AILA, Clinic, AIC, NLG, SCOTUS Blog, USCIS, Leifer Board of Justice Extern Joanna Velasquez, and Cristina Vasquez Law and Policy for their materials that were instrumental in my preparation for this CLE. Any mistakes are mine. With 15 minutes, this will not be deep analysis. This may sound like word salad. So if there is a radish that you're interested in, please follow up and read the case. They are cited in the slides, which will be sent after this presentation. So let's start. In Pareto versus Wilkinson, the Supreme Court holds that a non-citizen seeking cancellation of removal fails to carry his burden to show that he has not been convicted of a disqualifying offense when the conviction is ambiguous about whether it included that offense. Clement Pareto entered without inspection with his wife and 2 children. A 3rd child was born in the United States. Pareto gained employment as a cleaner, and he used an alleged false Social Security card. He was convicted of a Nebraska misdemeanor of criminal impersonation, which was the use of the Social Security card, and ordered to pay a $100 fine. Pareto might have been eligible for cancellation of deportation based on hardship to a U.S. citizen and lawful permanent resident relatives, but this relief is not available to non-citizens without lawful immigration status who have been convicted of a crime of moral turpitude under INA Section 240A. Nebraska's criminal impersonation law contains distinct offenses. The offenses that require intent to deceive are considered crimes involving moral turpitude under federal law. Pareto's criminal record does not make clear which specific conviction he had. Pareto argued that the court precedent would allow him to use the categorical approach to show that the state criminal conviction does not activate immigration consequences under federal law, as the conviction does not qualify as a crime of moral turpitude. The Supreme Court opined that where there is a divisible statute containing some offenses that are crimes of moral turpitude, the non-citizen bears the burden of showing that his conviction was not such a crime. Within the categorical approach, there's a threshold question of what offense the non-citizen was convicted of. and the court held this to be a factual and not legal question, and thus the provision in the INA that assigns the burden of proof to the non-citizen in removal proceedings applies. Next slide, please. In this Chavez versus Garland, the Supreme Court holds that a notice to appear, or NTA, which is the charging document that starts removal proceedings in immigration court, must contain the time and place of the hearing in a single document to start the stop time rule for accruing physical presence and continuous residence in cancellation of removal cases. A hearing notice that is issued subsequent to that NTA does not stop time if the NTA does not include the required information. Homeland Security served Mr. Niz Chavez with an NTA that did not list the time or place for his hearing. He applied for withholding of removal and CAT relief, but both were denied by the immigration judge. Mr. Niz Chavez appealed to the BIA, asking for remand to apply for non-LPR cancellation of removal. The BIA denied remand and relief was denied by the Sixth Circuit, which held that the stop time rule was activated when the government had given information required by INA section 239A1 when Mr. Niz Chavez received his hearing notice. The majority in Niz Chavez versus Garland reads INA section 239A to require a notice, meaning one notice. For those of you representing clients in cancellation of removal cases, look at the NTAs to see whether they contain the required INA section 239 information. Next slide, please. US versus Palomar Santiago challenges a removal order. Mr. Palomar Santiago is a Mexican national who became a lawful permanent resident. 8 years later, an immigration judge found that his California conviction for DUI was an aggravated felony and he was deported. Later, a Supreme Court case held that a DUI conviction, such as Palomar Santiago's, was not an aggravated felony. After returning to the United States, Mr. Palomar Santiago was found and charged with illegal reentry after removal. He challenged the charge, saying the original removal order was invalid. 8 U.S.C. Section 1326, which criminalizes reentry, requires a non-citizen to show 3 conditions have been met when he brings a collateral attack on the underlying removal order. He exhausted administrative remedies that may have been available. He was deprived of the opportunity for judicial review, and the removal order was fundamentally unfair. The Ninth Circuit ruled that defendants whose removal orders lacked a legal basis did not have to show the first 2 conditions had been met. So the district court dismissed the indictment and the Ninth Circuit affirmed. But the Supreme Court found that showing all 3 conditions had been met was mandatory. This case has implications for collateral challenges to reentry convictions in the Ninth Circuit, and we should all watch out for governmental pursuit of criminal reentry charges in all circuits. Next slide, please. In Garland versus Ming Dai, the Supreme Court determines that reviewing courts must accept the agency's findings of fact as conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary, pursuant to INA section 242B4B. Like the previous case, this may be of most interest to Ninth Circuit practitioners. In Garland versus Ming Dai, each non-citizen had asked to not be removed, citing fear of persecution if returned to the country of origin, but was found removable by the immigration judge. The BIA affirmed, and the Ninth Circuit noted that neither the immigration judge nor the BIA made an explicit adverse credibility determination under the INA, and then applied its own rule that a reviewing court must treat the non-citizen's testimony as credible and true, absent an explicit adverse credibility determination. The Supreme Court determined that the only question for judges reviewing the BIA's factual determinations is whether any reasonable adjudicator could have found as the agency had. Next slide, please. With Sanchez versus Mayorkas, the Supreme Court unanimously holds that temporary protected status holders who originally entered the United States without inspection are unable to adjust their status based on their TPS status. Temporary protected status may be designated by the Secretary of Homeland Security to a foreign country where there are temporary conditions that prevent nationals from returning safely, such as civil war, environmental disaster, or epidemic. The party to this case, Jose Sanchez, came to the United States without inspection from El Salvador. He was granted TPS in 2001 due to severe earthquakes in El Salvador. When Mr. Sanchez applied under adjustment of status process of 8 USC section 1255, which allows a non-immigrant foreign national lawfully present on a designated temporary basis to adjust to LPR status without leaving the United States, USCIS denied his application as his original entry was unauthorized. Mr. Sanchez prevailed at the district court, but was denied at the Third Circuit. Although he had non-immigrant status, he had not been admitted into the United States at a port of entry. The Supreme Court continues to distinguish between being in or maintaining status and being admitted. It requires a lawful admission prior to obtaining LPR status under Section 1255. Next slide, please. In Johnson versus Guzman-Chavez, the conservative Supreme Court majority rules that where a non-citizen is being detained during withholding only proceedings, the detention is governed by INA Section 241, detention and removal of non-citizens, and not INA Section 236, rules for mandatory detention. When a non-citizen who was previously removed returns unlawfully, he is subject to reinstatement of removal under INA Section 241A5, reinstating the previous order of removal, which allows expedited removal and limits relief available to non-citizens. The Department of Homeland Security may arrest and detain a non-citizen pending a decision on whether the non-citizen is to be removed from the United States. The non-citizen may generally apply for release on bond or conditional parole. If the non-citizen is ordered removed and the order becomes administratively final, and then detention becomes mandatory. This case arose when Mr. Guzman-Chavez, subject to detention due to a final removal order, claimed a reasonable fear of persecution if returned to his country of origin. He was referred to the immigration court for withholding only proceedings. Mr. Guzman-Chavez claimed INA Section 236 entitled him to a bond hearing because he was waiting for a decision about whether he would be removed. The Department of Justice said INA Section 236 does not apply because the prior reinstated removal order remained final, even if Guzman-Chavez eventually received withholding or deferral, and the Supreme Court majority agreed. Next slide, please. Here is a Board of Immigration Appeals decision. In matter of SLH and LBL, the BIA decided that immigration judges may exercise discretion to rescind an in absentia removal order and grant case reopening where a non-citizen establishes through corroborating evidence that late arrival at a removal hearing is due to exceptional circumstances under INA Section 240E1. Respondents are Guatemalan mother and son who entered the United States without admission or parole. The mother attended the initial master calendar hearing. She applied for asylum, withholding of removal, and CAT relief. She appeared for her individual hearing on the merits, but the matter was continued. On the continuance date, the mother did not appear, and the judge entered an in absentia removal order. 5 days later, the mother moved to reopen her proceedings based on exceptional circumstances which prevented her timely appearance. On her hearing date, the mother hired a driver, but the driver and she experienced severe weather conditions and related traffic accidents. The mother submitted affidavits, including from the driver and media, weather, and traffic reports. She had appeared timely for all of her previous court dates. The immigration judge denied the motion and the respondents appealed to the BIA. The BIA concluded there must be exceptional circumstances for a motion to reopen to be granted where it was closed for lateness. Exceptional circumstances could be established where the lateness is reasonable given the cause of the delay, the circumstances causing the lateness were appropriately exceptional, the weather and traffic conditions were not foreseeable, and the non-citizen provided sufficient documentation corroborating the cause of the lateness. The immigration judge should look to the totality of the circumstances and make a case-by-case determination when exercising discretion to rescind an in absentia removal order and grant a motion to reopen. Next slide, please. A.G. Garland's decision, matter of Cruz Valdez, holds that 2018 AG Sessions decision in matter of Castro Tomb is overruled in its entirety. Administrative closure temporarily pauses a removal proceeding and is a form of docket management. It is not a dismissal or termination of a case, but takes a case off the immigration judge's active calendar or the BIA's docket. Administrative closure facilitates prosecutorial discretion so that the government lawyers can remove low priority cases from the courts or the BIA's docket and focus on high priority cases. It allows a judge to remove a case from the active calendar when a pending related matter is being decided. Respondent is a Mexican national who asked the immigration judge for administrative closure of his case while he applied for a waiver, which if granted would provisionally waive the unlawful presence ground of inadmissibility, allow respondent to return to Mexico to process his visa at a consulate and return to the United States. The immigration judge and then the BIA denied the motion for administrative closure, the BIA citing to matter of Castro Tomb. AG Sessions in Castro Tomb determined administrative closure was not authorized by statute, regulation, or delegation from the Attorney General. After AG Sessions issued at Castro Tomb, the Department of Justice in 2020 issued a final rule to resolve inconsistency among courts of appeals. The final rule effectively codified Castro Tomb. The Department of Justice is currently reconsidering that regulation. While notice and comment rulemaking proceeds on the 2020 rule and with Castro Tomb overruled, except when a court of appeals has held otherwise, immigration judges and the board should apply the earlier standard for administrative closure. Last slide, please. Last week, the District Court for the Southern District of Texas found DACA to be unauthorized. As you know, Deferred Action for Childhood Arrivals was developed in 2012, allowing qualified young people brought to the United States as children to remain temporarily through renewable 2-year deferred actions to get work authorization and some state benefits. Texas and other states challenged the creation and operation of DACA, arguing that it interfered with its sovereign powers and commercial and economic interests. It claimed that Homeland Security did not go through the notice and comment procedure in adopting DACA. The District Court agreed. Congress has not given DHS power to implement DACA, and DACA is not authorized under the department's inherent authority to exercise prosecutorial discretion. So current DACA recipients continue with their status pending further order. Homeland Security may continue to accept new DACA applications and renewal DACA applications, but may not approve new DACA applications. No immigration, deportation, or criminal action may be taken against a DACA recipient based on this decision. Texas versus US is likely to be appealed. On to you, Jesse.
Okay. Well, first of all, I feel like you deserve a round of applause. That was an incredible amount of information. And I wish law school would have been like that, so concise and to the point. What I'm going to talk about is I'm going to talk about kind of some of the developments here on the border, and I'm going to take kind of a practical approach that I hope will be helpful for current practitioners, but also non-practitioners. I know we have a lot of public defenders on this in the CLE. And so particularly with public defenders, if you guys have questions about any of this stuff, it would be really great if you guys could chat your questions. And then that way we can try to answer them at the end. I'm not going to take a lot of time to go through this, but I want to be able to get to some of those questions because I know I've been receiving a lot of questions from y'all about how these things are affecting clients. So the first thing I want to talk about is the dismantling of the migrant protection protocols from the Biden administration. So just as a refresher, the migrant protection protocols were a horrific policy put together by the Trump administration and implemented on the border, which instead, when an asylum seeker, when a person came to the border asking for asylum, instead of being permitted to pursue their claim in the United States, either in a detention facility or under what we call alternatives to detention, which is kind of like, what do you guys call it in criminal law? Pretrial supervision, right, with an ankle monitor and check-ins and things like that. Instead of that, which is what is required under the law, the Trump administration sent all of those people back to Mexico, to Juarez and Tijuana and some other cities, which are notoriously violent and scary, and required those people to wait for their cases to proceed there. And then when they had court, you know, they'd be allowed to come in for the day. They would be under guard the entire time. We're including, you know, women and children who had been through traumatic events. And then they'd have to go back to Mexico and wait for their other court date. Well, this policy was horrific. And thank God, when Biden took office, they formally have banned the migrant protection protocols and are in the process of dismantling it and processing everyone who was enrolled in MPP into the United States in an orderly way. There are different phases for those folks to come into the United States. And currently we're in phase 2. Phase 1 provided a structure to allow people who had been principally enrolled and with their children to be paroled into the United States, who are still in proceedings, meaning that they still had upcoming court dates. Those folks are still being processed in, but in the meantime, phase 2 has also begun, which allows folks with in absentia orders also to be paroled into the United States and for their cases to be reopened. So when we talk about in absentia orders, what we mean is, and this is horrifying for immigration attorneys as well, but what it means is that if you don't show up to court in immigration proceedings, your case is summarily decided for you and it's decided against you. And so in MPP, what was happening, so a lot of people became very fearful to show up to court because when they were going back to Mexico, they were being targeted by smugglers and kidnappers and organized crime. They were being kidnapped, held for ransom, beaten, raped, and killed as they were coming off the bridge. So a lot of people decided not to go to court, which I think is understandable. Those people ended up with in absentia orders. And so what phase 2 allows are for those people to register, show that they were enrolled in MPP, and then there's an agreement between the government and CBP that ICE will agree to reopen all of those cases so that folks can come in, they can remain in the United States and their cases can be restarted from scratch. So that's phase 2. Phase 3, we don't really know what will happen. Folks who work directly with UNHCR and some other groups on the border, I think have a better idea, but that won't be for a little while. I did want to include, and I've included on a couple of these slides, opportunities for folks who are interested in helping. So as we speak, there are a group of UNM law students and our own Professor April Land are actually in Juarez today, helping to process people in under phase 1 and phase 2. And so if you are a Spanish speaker and you're a US citizen or a lawful permanent resident, and you would like to go to the border and help to process these folks in, you can get in contact with me. It does require a trip to Juarez, and the reason it has to be a US citizen or a resident is because you have to have the ability to come back into the United States, even pending all of our travel restrictions due to COVID. Next slide. Well, first, let me stop there. Are there any questions about that? Okay, next slide. Okay, let's talk about prosecutorial discretion. So prosecutorial discretion in the immigration world is this thing that we talk about like it's a unique thing within immigration law. Prosecutorial discretion, all that it means, you have it in every other area of law. All that it is it's like, when the prosecutor exercises their discretion to dismiss a case that they don't think they can prove. Right? That's what prosecutorial discretion is. But in immigration law, it's become a very politicized issue about whether or not we provide the ICE attorneys or the DHS attorneys the ability to make these assessments about which cases they should go forward on and which cases they shouldn't. Additionally, prosecutorial discretion applies to the executive branch and determining which folks, which undocumented immigrants they want to proceed with and try to expel or deport from the United States, and which folks they don't want to expend those resources. And so under the Obama administration, there were pretty good guidelines in terms of who would be prioritized for enforcement and who would not be prioritized. Under the Trump administration, all of those guidelines were rolled back, and they said they were prioritizing everybody, regardless of criminal history, how long they had been here, age, health, if they were pregnant, all of those things kind of went out the window, and they started prosecuting everybody, meaning that if you encountered a immigration officer, you were being placed into removal proceedings. And then once there, the ICE attorneys and DHS attorneys were going to work as hard as they could to make sure that you were deported from the United States. This was very harmful, both on a humanitarian level, but also from kind of an efficiency level. This is the reason that we have a giant backlog in our immigration courts right now, because all of the cases we're getting, we'll say indicted, right? We're being brought in front of the immigration court, and none of them were being dismissed. Now, there are new guidelines. The guidelines under the Biden administration are much, much better, much more generous than even under the Obama administration. And basically they say that you're supposed to only enforce, only prioritize for enforcement 3 groups of people. People who are national security risk, whatever that means, right? Obviously people who have convictions for national security things, but it's also gonna mean people who might be implicated in an FBI or an HSI or a DHS investigation as being involved in international terrorism or something like that. The second group is going to be what they call recent entrants. This is really important because recent isn't as recent as you think. Recent entrants is anybody who entered after November 1st of 2020. So anybody who entered after the presidential election is considered to be an enforcement priority for the Biden administration. And we'll talk about in a moment kind of how to rebut that presumption. And then the third are people who are convicted of aggravated felonies. Aggravated felony, as our FPDs know, has a very specific meaning in the law and under the Sentencing Act. We have the same definition in immigration proceedings. So, when you're pleading people to things, aggravated felonies have always been really scary, but they're really scary for this reason, because they can make someone who is not an enforcement priority suddenly an enforcement priority for ICE. Now, that's who is supposed to be covered by prosecutorial discretion. In addition to providing those guidelines, which apply to ICE, right? ICE generally, the cops, ERO, HSI, everybody across the board. In addition to that, OPLA, which stands for the Office of Principal Legal Advisor, those are the ICE attorneys, they were provided recently guidance on how they should apply those enforcement priorities. And if you will click, Rebecca, on that link, I think it'll let you come up. I don't know, maybe it'll mess with the screen sharing, but let's try it. Okay, that's the second link, which I can talk about. Actually, do you mind, can you click on that first link, the civil immigration? Great. Okay, this is the memo that came out. And what it does is it talks about those 3 groups of people that ICE should be prioritizing. But it goes further and it says, even if you fall into these 3 categories, OPLA attorneys should also look at a couple of other things to determine whether or not to proceed on a case and whether or not to exercise their prosecutorial discretion in removal proceedings. And thank you for highlighting that. So the things that they're looking at, and this is important, are going to not just be, whether they have an aggravated felony, it's also going to be generally what their criminal history is. And so for those of you who are pleading folks to non-aggravated felonies, or maybe you have a client who has been ordered deported in the past, right? And you want to be able to set them up to be able to ask for a stay of deportation or some other ability to remain in the United States, even though technically there's a basis for their removal, you want to try to avoid recent and serious criminal convictions and criminal history that would show that they're not, quote unquote, deserving, right, of prosecutorial discretion. You're going to look at other mitigating evidence, but really we're looking at rehabilitative evidence, unfortunately. So anybody who has like a ton of DWIs, you know, you want to counsel them to make sure that they're completing their rehab programs, that they're keeping really good records, and really, really importantly, that they're getting in touch with an immigration attorney as soon as possible so that they can discuss their options and asking for prosecutorial discretion on their cases. Additionally, you're also going to look at their family members, if they have US citizen or LPR family members, if they have children, if they're caregivers to their parents or their children, if they have health issues, those kind of equities, right, that would tug at the heartstrings of a prosecutor and saying, I don't think that I should ruin this person's life because they're here without status. Can you go back to my slide, Rebecca? The other way that prosecutorial discretion can be applied, which is really helpful, is if your client is already in removal proceedings, prosecutorial discretion can be applied to get them out of removal proceedings. And so you can go and ask the ICE attorney to dismiss the case completely and take your client out of removal proceedings, or as we'll talk about in a moment, to agree to administratively close proceedings, which can have benefits. You can also ask for the attorney to stipulate to certain elements that you need to meet in order to qualify for relief. And so it's a really, really powerful tool. The bad thing about the way that this guidance is being implemented is that it really makes clear that ICE is not going to proactively review cases for prosecutorial discretion. The immigrant has to ask, and they have to present all of this information and ask for prosecutorial discretion. And so the second link goes to kind of the guide on how to request prosecutorial discretion. And it's a little infuriating because when you talk to OPLA, they're like, we really want to get this out to pro se respondents. You know, if you guys can help us locate people who don't have lawyers, you know, they really need to know how to ask for this. But we all know in reality, pro se respondents are not going to find out about this like they should. And they're not necessarily going to know how to ask for this in a way that OPLA attorneys are going to require in order to apply prosecutorial discretion. So one of the things that if folks are interested in helping immigrants, and as a lawyer or a non-lawyer, you can help do, is organize a pro se workshops on requesting prosecutorial discretion. I know that here in El Paso, there are discussions with DMRS to try to do that. But if folks are interested in helping to organize that up in Albuquerque or in Santa Fe, we can certainly plug in immigration practitioners to help you guys with the actual workshop. Okay, next slide. Okay, administrative closure. It's back. I'm not going to talk about the case because I think Professor Suzuki did a great job. What I will say is the way that administrative closure is extremely helpful is that it allows your client who's in removal proceedings to put their case on the back burner of the court's docket and to continue to live in the United States without fear of having to be deported. The way that it's different from a dismissal is that the case is still technically pending. And the reason that that's beneficial, oddly, is that it allows the vast majority of folks to continue to apply for a work permit. And so your client will remain undocumented, but they will also continue to have the ability to ask for employment authorization document, which will let them get a driver's license, will allow them to travel freely in the United States, and of course will allow them to work. But again, you can't ask for administrative closure unless you know that you need to ask and you need to present it in this particular way. So again, folks who are interested in helping, if you want to help organize a pro se workshop, I'm happy to coordinate with y'all. Next slide. Quickly, and those are all good things that have happened, right? Here's another thing that I think is good, but the Biden administration is very proud of this, and that's troubling. They're very, very proud that they've issued new guidance that they're not going to detain pregnant and nursing women anymore, which is good. That's total progress, right? But it's also like, oh my gosh, I can't believe that we were detaining pregnant women. Anyway, they are going to start a program to identify and stop doing that, which is good. Generally, you can also look at interim guidance, which I had discussed about the 3 enforcement priorities to determine kind of detention policies. But I wanted to highlight this slide because I wanted to let y'all know that while things are definitely getting better, they're still horrible. There's still a lot of people detained right now. It's mostly adult men. And right now it's a lot of men from Haiti, actually, because of the horrific things that are happening in that country. It's Central American men, men from India as well. And so there is still a problem with detention. If you are interested in getting involved in kind of the abolitionist movement of immigrant detention, you can also get in touch with me. You can also get in touch with Allegra Love. They're in Santa Fe because she works a lot on that issue. Next slide. Finally, the end of Title 42. Title 42 is a policy that has been in the law for like 50 years that says that if there is a pandemic or communicable disease, that the government can stop people from being able to come into the United States who they believe are at increased risk of having that communicable disease. The Trump administration weaponized this very old and arcane part of the law in order to stop asylum seekers from accessing asylum protections in the United States. And that policy has continued to be implemented by the Biden administration. They have repeatedly said that they're going to end Title 42. This is me waiting for the end of Title 42. There is some ability to accept certain people from Title 42. It's very secretive, it's very hard. For the most part, that people are not being able to proceed on their asylum claims. So you're getting MPP, which I talked about before, right? You're getting kind of the same result, but worse, because people are still stuck in Juarez, but they don't even have the ability to come into the United States and proceed on their claim. As a result, there are a lot of people in Juarez and Tijuana and other border cities in Mexico who are the victims of kidnapping and rape and violence and all of those horrible things, in addition to also going through, an economic depression due to the COVID-19 pandemic. And so Title 42 has not ended. We are hoping that it will slowly start to be repealed by the Biden administration, but we're still waiting. If you're interested in helping, Spanish speakers can contact me for remote volunteer opportunities to help get folks who are particularly vulnerable out of Title 42. So that's my update. I'm going to say we have 5 minutes because we started a little bit late. So if anybody has questions, now would be the time.
Also, to add a little plug, we have another CLE next week, and it will be in coming up to speed on the new normal with the massive changes that we've seen with asylum law, especially as they relate to families, domestic violence, and gang violence. We have Christina Brown, who's a renowned expert on asylum law, who will be providing that CLE for us. So.
Are there any questions? And I know that there are a lot of public defenders on here who have questions. So now would be the time. You can either speak up or you can write your question in the chat. So the question is, what is the Biden administration doing to reunite families who are separated at the border? So there is a task force that has been put together to do exactly that. To be honest, I'm not 100% familiar with everything that they're doing. My understanding is that there were a number of initial parents that were paroled into the United States, or children that were paroled into the United States to be reunited. That was a couple of weeks ago. And actually some of those clients were clients of America's Immigrant Advocacy Center here in El Paso. I haven't seen anything since that, but my understanding is that they're undertaking kind of several different paths to make sure that they're reuniting families, but also to locate families that they didn't even know that they had separated, that there were no records that they had separated, and they're coming up with more and more families that has happened to. So beyond that, I don't know any of the specifics, but I'm happy to connect you if you're really interested in that with Las Americas Immigrant Advocacy Center, as they are directly involved in those efforts.
All right, well, I think that was the only question that we had. And there's some additional information in the chat as far as if you want to get involved with the Leafer Border Justice Initiative. And also email us for if you are having any issues with the CLE certification link. Thank you all for coming.